Welcome, members and guests. Today is Tuesday, March 16th, 2021. I hereby call the Property and Planning Subcommittee to order. Will you please take the roll?
Representative Hodges? Here. Representative Leatherwood? Representative Reedy? Here. Representative Sexton? Representative Wright? Here. Chairman Moody? Here. Chairman Carter? Chairman Crawford?
Here.
Chairman Crawford, you have a quorum.
Thank you, madam. I need to announce for the record that Representative Carter and Representative Jerry Sexton are both excused. Are there any personal orders from the committee? Seeing none, let's get into our agenda. We have 5 bills on the calendar today. I think we will be able to get through these pretty quick since we have 2 that's been taken off notice. Our first item on the agenda is House Bill 358 by Speaker Pro Tem Marsh. He has asked that this be taken off notice. Without objection, we will take it off notice. Item number 2, House Bill 1326 by Representative Hardaway. Do I have a motion? Motion. Proper motion. Second. Representative Hardaway, you're recognized on House Bill 1326.
Thank you. Thank you, Mr. Chairman. And House Bill 1326, the genesis of this bill is from individuals in Shelby County who have done lease to own or rent to own contracts for homes. As you know, we're in difficult times, economic times, and sometimes when the consumer is in such a position, it's easy to take advantage of them. This simply requires that that document would be recorded in the registrar's office. I've been consulting with my registrar in Shelby County, my trustee, and the various registrars from around the state. And by the full committee, we will actually have a resolution from those respective organizations endorsing such.
You've heard the explanation. Is there any questions? We have a member that would like to speak. Can withdraw that. Thank you. Representative Reedy, you're recognized.
Thank you, Representative Hodges. Mr. Chairman, appreciate that. Representative Hardaway.
Yes, neighbor.
State again about the resolution. What do you have going on?
I've been in conversation with the trustee and the registrars, members of those associations, and they support the bill, and they will have resolutions by the time we get to full committee in support of the bill.
Thank you.
Representative Reedy?
I guess with that, Mr. Chairman, I'm going to be a no at this time. Is there a chance that we can maybe roll this so we can get those resolutions in our hands before we proceed?
Well, we could, Mr. Chairman, but
I'll leave it up to
that's
the
more
chairman.
gravy than anything else. The bill is simple. It simply puts an extra layer of protection for the consumer by making sure that that document that some of the credit challenged citizens will sign and put up considerable down payment, that should they lose their copy or if there's some dispute about what was original, that we will have an official copy that will be in the registrar's office. That's all it does.
Follow up, sir? Good. Representative Leatherwood, you're recognized.
Thank you, Mr. Chairman. A couple of things come to my mind with this bill. One, straight out mortgage with bank, like most of us probably had at one time, is not required to be filed in the registrar's office. It may be, but it's not required. So that's one thing. And then two, I believe there's nothing in the law keeping this from being filed in the registrar's office now. As a matter of fact, I believe it could be filed in the registrar's office now. And if we needed to defer to legal to confirm that, we could. But I don't really see the necessity of this.
Representative Hardaway, do you like to respond to that?
Yes, sir. And I'll go back to my opening statement. It's about the consumer who typically would execute such a document, lacking the sophistication of the typical home buyer who goes through a mortgage company, who has the input of a closing lawyer, quite frequently of a real estate professional. Quite often, these contracts of rent-to-own or lease-to-own are done simply between the owner and the tenant. And there's an imbalance in the professional knowledge then and ongoing. So it's not a matter of whether it can be done at this time. It's a matter of whether it should be done. And I believe that's in the best interest of the consumer because of that imbalance in knowledge that it should be filed. I've had incidents where constituents have not kept up with the paperwork. I've had knowledge of instances where there's disagreement on what was actually on the original document because the document the copies were not provided to the tenant. So there's a need for it. And the same way that we look out for tenants in other consumer affairs, we protect our citizens from predators in the financial industry. This follows that same trend.
Is there any more questions, follow-up?
Wouldn't that same logic apply to a rental agreement? So should we start recording all rental agreements with the registrar's office? It seems to me like the same logic would apply if a rentor loses their lease or if the property owner seems to change the rules of the game. It seems like the same logic would apply to a rental lease to me. But that's just my thinking.
Representative Hardaway, would you like to respond?
Yes, sir. I think the rental agreement, Rep. Leatherwood, would be an option. There's not the type of tremendous amount of money that's usually put down on these lease options that would be comparable to the typical rental agreement, simple rental agreement, which might be 1 month's rent. Whereas on these lease to purchase or rent to purchase contracts, it will be thousands of dollars. It's usually a percentage of the eventual sales price. So I would suggest to you that there's a big difference.
Representative Wright, you're recognized.
Thank you, Mr. Chairman. When we get into the sale of land, we open a big existing can of worms. When you first approached me about this, I thought, it sounds like a good idea, but how does this fit into the current framework? So now that I understand more about it, this is looking at property that is destined to change ownership. Is that correct?
Representative Hardaway.
Thank you, Mr. Chairman. If the conditions are fulfilled by both parties, yes, sir.
Follow-up, Mr. Wright.
Yeah, so then my comment would be there are maybe 30 or 40 different kinds of deeds in the state of Tennessee. One of those deeds is a deed of trust, which the ownership is retained by the seller until the workings of the contract are complete. So you're describing to me what is a deed of trust, not a quick claim, not a warranty deed, not a gift, not an inheritance. Those are all different forms of deeds. A deed of trust is where there is a contract entered into and the ownership is retained until the contract's complete. That sounds like the perfect way to record this anticipated transaction. And that's all I had to.
Representative Hardaway, I'm going to take a point of privilege right quick. Mr. Sergeant of Arms, can you check the temperature in the room? It seems to be really, really warm up here. You're recognized, Representative Hardaway.
All right. Thank you, Mr. Chairman. And to the Chairman, you're exactly correct. This is comparable to the deed of trust, but it's also comparable to the mortgage. That's why it's important that this gray area be addressed. Your typical deed of trust is not going to set out the terms. Your mortgage is. However, when you enter into that contract for the rent to own or lease to own, you're going to have the terms set out comparable to the mortgage and the terms for the transfer comparable, retaining the ownership, simply comparable to the deed of trust. So I agree with you. It has some of the same content that you would find in the deed of trust, but also you'll find that it contains some of the same content of a typical mortgage.
Any more questions for Representative Hardaway? Seeing none? Representative Leatherwood, you're recognized.
I appreciate your indulgence.
And my apologies for always shifting over, but that's the only way I can see you.
For those that might not know, I was Register of Deeds for 18 years, so I mentioned something to legal. Reflecting on it, listening to the conversation, I really have more concerns about this bill than I did before, because I think the pertinent TCA says the register may file, or whatever the terminology is, and then there's a long list: mortgages, warranty deeds, everything we've talked about. You know, none of this is required by statute. So I really wonder if we're going to require this one, and maybe there's a property owner that's not so savvy, kind of like you're talking about the buyer. Maybe the seller's not so savvy, and he doesn't file this, but the law requires it. While the law doesn't require the deed to our house, the mortgage to our house, I'm concerned you'll put a cloud on this title for both of them if it's not done when it's required. So I just have grave concerns on this bill. Yeah.
Any more questions?
Am I correct? Does it say may?
Without objection, we'll go out of session to hear from legal.
Thank you, Mr. Chairman. Doug Garrett with Legal Services. That's correct. And I'll make reference to the cited 66-24-101A, that the following writings may be registered. And there's a litany of types of deeds and every other sales, contracts for the sale of land included in there. So it is, I think that's the crux of the issue, that this is permissive currently.
Without objection, we'll go back into session. Any more questions? Seeing none, we're ready to vote.
Mr. Chairman,
Yes, sir.
I would ask that I want to make sure I address the concerns specifically in terms of the may, in terms of the resolution, in terms of can't remember exactly what yours was, but that I get an opportunity to address those concerns by having individual meetings. So I would ask that we don't take a vote today even though I'm confident that my members trust me enough and would send me out of here, and that we push the bill to next week.
So are you asking for a roll then?
Yes, sir.
Without objection, this bill's rolled 1 week.
Thank you, and thank you, members, for the discussion.
Item number 3, House Bill 0818 by Representative Clemens. Do I have a motion? Motion. Proper motion. Is there a second? Second. Representative Clemens, you are recognized on House Bill 818.
Thank you, Mr. Chairman and committee. I appreciate the attention to this matter. What we have here in Nashville is an affordable housing crisis. And over the past few years, during my tenure, I've had the opportunity to pass some laws that just provided permissive tools to our government and other county governments to address this problem. What House Bill 818 would do was simply make a tweak to the mixed finance project definition within the code. That's Section 1 of the bill. Section 2 of the bill expands the powers of a housing authority with one provision there to allow housing authorities, if allowed by a county government, in this case the Metro Council, to create or delegate that housing authority to negotiate and accept payments in lieu of ad valorem taxes from the housing authority's lessees operating mixed finance projects. But again, that such authorization must be granted only upon a finding that such payments are deemed to be in furtherance of the housing authority's public purposes. So fully transparent, purely permissive, simply creating one more tool in the toolbox for private entities to help build affordable housing through the permission of the local council or local county government in coordination with the housing authority. And Mr. Chairman, committee, I have Councilwoman Berkeley Allen here, who I consider an expert on this topic. She has served in the Metro Council for 10 years now, 11, yeah, and she works on this issue quite a bit. So if you wouldn't mind going out of session, she can speak briefly on this topic and answer any questions you have of any details.
Representative Clemens, give me one moment. Is there any questions for the initial address of Representative Clemens on the bill before we go out of session? Seeing none, we will go out of session. You have 3 minutes, Mrs. Allen, to address the committee. Out of session.
Mr. Chair, thank you for the opportunity to address this committee. I'm Berkeley Allen, a member of Nashville's Metro Council and past chair of our Affordable Housing Committee. I'm here to ask for your support of HB 818 by Representative Clemens. This bill would simply broaden the applicability of payments in lieu of taxes, pilot, that housing authorities can negotiate to further their mission. Pilots have been used very successfully to leverage funding to build housing that is accessibly priced for people earning less than the area median income. I believe every city is hearing the same question that we are as we work to bring businesses to Tennessee. Where will my employees be able to find the housing they can afford? The need for reasonably priced housing is an issue for residents and increasingly for businesses all across the state. Our economies depend on people like our service workers, teachers, construction workers, firefighters, police officers, and nurses, and we need to ensure that they can find housing reasonably close to their jobs. If they have to go to the next county to find housing they can afford, then they become part of our traffic congestion problem, and their punctuality and dependability can suffer. This affects both the employee and the business they work for. Pilots have been used in conjunction with low-income housing tax credits, LIHTC, for several years to facilitate the construction of hundreds of units that are affordable for middle-class workers. Builders who do not have access to LIHTC have repeatedly maintained that they could also contribute to this need if they could count on some kind of tax abatement as an incentive. This bill would allow cities to create their own programs to offset lower rents with specific tax abatements. The Metro Council recently passed RS 2021-800 supporting HB 818 because we believe we can use the very successful LIHTC pilot model to create a similar program for for-profit builders to set aside a portion of the units in a multifamily project for income-qualified renters. The tax break would be sized to equal the difference between market rate and affordable rent, which is defined as 1/3 of the renter's income. This would help add badly needed affordable housing in the areas where the jobs are, in the context of mixed income development. Mixed income housing deconcentrates poverty, helps relocate people to areas of opportunity, and adds to the diversity of neighborhoods. This expanded pilot tool could benefit any county that is struggling with having a diversity of housing, and it could allow all builders to participate, even if they're not experienced in the very complex kind of funding used for LIHTC. This is good for all of Tennessee, and I ask you to support it. Thank you very much.
Before you leave, is there any questions for the speaker? Seeing none, we'll go back into session. Representative Clemens, you're recognized on your bill.
Thank you, Mr. Chairman and committee. And as Councilwoman Allen referenced, the Metro Council did pass a resolution in support of this. And I provided a copy of that to the chairman prior to this hearing. And so I would respectfully ask for your support to provide our counties a tool to build affordable workforce housing if necessary.
Any questions for the sponsor? Representative Wright, you're recognized.
Thank you, Mr. Chairman. A question of the presenter now, the difference between where we sit right now with the Metro government being able to provide pilot or TIF, I don't know which, I don't know how many tools are in your toolbox right now. The difference between where you are right now, what is this actually going to do that makes the program then work? Where is the money coming from?
Representative Clemens?
Thank you. And again, Councilwoman Allen need to correct me on this, but right now, the program that's working is working fine. This just adds a layer to it. What we have here is private developers or private entities that want to engage in this, and that's what this would add. So if you have a private developer wanting to do this as a lessee, a property owned by an MDHA, for example, they can then engage in this through a pilot. It's just simply one more thing. It's not saying that some things that are currently existing aren't working. This is just one more tool to provide some more opportunity.
Follow up, Vice Chairman?
And that's what I'm having trouble grasping is what is that one more tool?
Representative Clemens?
Yes, okay, go ahead.
Well, so what this would do, and I think Councilwoman Allen touched on it, is it's going to enable entities such as Metropolitan Council to consider the legislation, guiding that, and the implementation of the pilot program for mixed finance projects to ensure that the tool is used fairly and in a responsible way. And so here in the resolution that was provided to you, it broadens the use of pilots to include mixed finance projects. That's the reason for that section of the bill, in addition to LIHTC properties or low-income housing tax credit properties that contain the affordable workforce housing component that would allow for the construction of more affordable housing and more quickly address the critical housing needs. So it's just that additional tool to provide that opportunity. And is there anything you would add? Can we go to session and she can answer the question more specifically?
Is there any objection from going back out of session? Seeing none, we're out of session. You have a 1-minute response, ma'am.
Very quickly, just what this adds is the ability to use the pilot, which we have used so far only for low-income housing tax credit projects. That it was created specifically to meet a need on low-income housing tax credit projects to fill a gap for the income tax that they have to pay on the value of their credits. And the discovery was it has been the most successful tool that we have used and has created the most number of units of housing. So this would then expand it so that the projects would not necessarily have to have a LIHTC component, but that they would still be able to be covered for the portion of the units that are income qualified to make up the difference between market rate and the rate that would be charged to those renters. So it allows someone to still make a profit on a project, knowing that they've lowered their operating costs by having the tax abatement.
Thank you, Ms. Allen. Is there any questions for Ms. Allen before we go back in session? Representative Reedy.
Thank you, Mr. Chairman. And I'm trying to find a need out of the discussion. So already the projects are moving forward and things are happening. Okay, so you're saying,
There are low-income housing tax credit projects that happen when they
Right.
win the low-income housing tax credit award. But they are not meeting the thousands of units that we need to do that. And there's a limit on how many low-income housing tax credit are available. So the for-profit builders have continued to say to us, we could build units and offer some at a lower rent, but only if we can take to the bank that we know our operating costs are going to be lower. This is one tool that you can use as a tax abatement. And the only way we can offer tax abatements are through the tools
Through
that exist in the
legislation.
state. Correct.
okay, because that's where I'm looking at, of course, it says the bill changes such authorization to include delegation to the housing authority. And is that a part of what you're, as a city, county, is not allowed to do at this time? And by making this delegation, then that's the additional thing in the toolbox we're talking about?
Currently, it is only allowed for.
Miss Allen, you're recognized.
Excuse me, I forget. Currently, it is only allowed if that project has a low-income housing tax credit. This does not, it expands the authority that our housing authority has.
Representative Reedy?
Because I certainly don't want to create a runaway train with different cities, councils. And it looks like present law authorizes the city or county for which a housing authority is created. So is every county have a housing authority that this would help, or are we just talking about our larger cities, counties? Or
Mrs. Allen?
do you know?
I cannot answer that authoritatively. I know your larger cities do have them.
Okay.
Follow up,
Thank you,
Representative Reedy?
Mr. Chairman. I'm good.
Thank you. Any other questions for our speaker? Seeing none, we'll go back into session. Representative Clemens, you're recognized on your bill again.
Thank you, Mr. Chairman, and I appreciate you allowing Ms. Allen or Councilwoman Allen to answer those questions. Like I said, she's much more knowledgeable in this than I, and I'm the recipient of this legislation on their behalf. And other counties do have housing authorities. I can't say affirmatively that all 95 counties have them, but more counties than just the big cities have them. And so this is available to any county, but that's a key component too. The local government has to authorize them under this legislation. This isn't a requirement. There's a double check here. So what you're doing is empowering the local government to assign or delegate this authority to their housing authority if they want. And then when that decision's made, the council then would approve it in Nashville's case after. So you got a double check there with the transparency when the tax abatement issues arise.
Representative Reedy, you're recognized.
Thank you, Mr. Chairman. Representative Clemens, I guess that's where my concern is for the city or county just delegating their authority to somebody else. And I see in Washington, D.C., that's become a problem. We certainly don't need to start delegating stuff out to unelected officials in the state of Tennessee. Thank you, Mr. Chairman.
Representative Clemens, would you like to respond?
Yeah, I mean, I think that's the inherent benefit of this legislation is we're empowering local governments to use a tool, but they by no means have to use that tool. And, you know, I think the local governments generally appoint these housing authorities, so it's imperative to have individuals on there who are making those decisions. But once they even make that decision, it then comes back to the governing body again to accept that tax abatement in Metro Council's instance. So you've got a double check on the process here by elected individuals. So I think the protections are in place. The process here, it's so badly needed, and I know it is in Sevier County, and I know it is in many other cities and counties. You know, this just gives us another opportunity to facilitate this type of development for private developers who really want to do this and help, you know, address a real problem.
Any more questions for the sponsor? Seeing none, we're ready to vote. All those in favor of House Bill 818, say aye. Aye. Those opposed, no. No. The noes have it. I'm sorry, Representative Clemens, your bill fails. Item number 4, House Bill 0034 by Representative Cooper. Do I have a motion? Motion. Proper motion. Is there a second? Seconded. Representative Cooper, as soon as they get done cleaning the podium, you will be recognized on your bill, ma'am. Good to see you this afternoon. Yes, ma'am.
House Bill 34 authorizes the Tennessee Housing Development Agency, THDA, to provide eligible displaced tenants with affordable housing and services in addition to any relief provided under federal regulations for displaced tenants and relocation assistance. And I ask that you hear me this afternoon to tell you why I brought this to you.
Yes, ma'am.
Yeah, I have the motion in a second, and thank you for that. It states in the fiscal note, and there's no impact on the fiscal note, it's non-significant. But I had a very, very big concern because I had tenants calling me about displacement and housing repairs, roofing. Now, I know that the Tennessee Housing Development Agency has the authority in talking with the director to assist people with housing and repairs. I have letters dating back in 2018 asking for some assistance for a senior citizen in his roofing, and it's caved in now after 3, and he's still on a waiting list. I had another constituent who is disabled and was dislocated in a housing development. I didn't know it, but she lives in my district, and of course both of them do. And she has been asking in Section 8, she was displaced. You know, when you come in and redevelop and develop the different areas, the tenants have to move and reapply for housing. And she was overlooked inadvertently. I'm sure it was an error. She kept going down trying to get her assignment, her home, and she never did get her apartment. So she finally wrote me or called me, she and her mother, and this was in 2019. Then I followed through with the letters until 2020. I have some here. And the final letter that I had received from the Memphis Housing Authority and Community Development is that they didn't really accept not placing her. I don't know what happened. She's just one of those, sometimes things fall through the cracks. But they did not attempt to try to find her housing. What they did on the letter, they just sent some suggestions on where she should go to HUD and 2 or 3 other telephone numbers to call to get her own replacement. Now, after this long period of time, you know, she has been trying to manage, and she's on commodities and not able to get into place. So I just really here to get your help through legislation. And I understand from the director and some of the staff that they leave it up to the cities and the counties. But sometimes when the cities or counties don't do their due diligence, I would think that the housing authority would investigate and try to find out what's going on, maybe how many people are being served, those who are not being served, how many on the waiting list, and whatever information they need to serve the people. So I'm asking your support in making sure that the housing authority, and I had a note from the housing authority, I talked with them over the last 2 or 3 years about the complaints that I had been receiving. Very kind, and let me just give them recognition. I had something here, a note from them that they wanted me to get back with them, and I will after the bill is considered here today.
Yes, ma'am. Is there any questions for Representative Cooper? Representative Wright, you're recognized.
Thank you, Mr. Chairman, and thank you, Ms. Cooper, Representative Cooper, for bringing this legislation to us. It's only due to the last election that I'm a sophomore member and not a freshman member. So I sometimes have trouble asking questions because I don't know all of the acronyms or what they're all responsible for. But the THDA, as an organization, I think, I'm asking the committee now, has been established in order that there be funds available for people to borrow money and purchase a home. In fact, the cap on the amount of money that they were able to access, I think, was increased sometime in this 2 years that I've been around. How does the saying we're going to place people with THDA, how does it affect their overhead or their operating budget? They do not take people just to be placed in housing. It's got to be someone that's approaching them to borrow money and get a roof over their head through the normal process of buying, but at a better rate or a better guarantee or a better. The THDA is a nonprofit, but they still got to cover their operations, what I'm getting at. So how does that square with what you're asking us to do?
Representative Cooper?
Thank you, Mr. Chair. And we may have to ask legal to help me with this. My understanding, and I may be incorrect, is that at the Tennessee Housing Agency has funding to assist cities and counties with housing for senior citizens, disabled people. These are set of senior citizens. And when you, for an example, sometimes our housing developments are antiquated, need to be torn down. The developers come in and they tear it down, the city and the county approve. They take those people who are in those housing developments and give them temporary housing or allow them to stay there until development, before development begins, and they are displaced or given some temporary housing, and they'll assign them to housing once they have displaced these tenants so that they can develop, just to develop the housing area. Now, I was all involved with one because they had so many different problems going on in the district. But this one particular one was, as I said, the tenants must be moved so that the development can go on. Once the development is completed, these tenants are supposed to be either come back to that particular development or they are placed in a new housing. So this particular lady was just inadvertently left out. Now, I don't know whether I'm answering your question or not, so maybe legal can help me with this. But the other thing was the roofings, the apartment housing, the housing repairs. That the THDA had some authority to check on those folks who provide money or funding to assist with housing repairs for senior citizens.
Representative Cooper, let me, Representative Wright, did that answer your question, or do we need to hear from legal? Okay, without objection, we will go out of session, hear from legal, out of session.
Thank you, Chairman. Doug Garrett with the Office of Legal Services. And Representative Wright, your question pertains to the authority of the THDA relative to making funds available and that sort of thing. That was your question, right? And how that dovetails, if at all, with what the bill does. The THDA, by statute, is given the power to raise funds from private investors through the issuance of bonds and notes, and to use such funds and monies from other public and private sources, and I'm just reading from the statute, to make funds available for various and sundry purposes. And that is the predominant authority of the THDA. There is another provision in statute that authorizes them to provide technical and consultative and project assistance services to sponsors of land development or residential housing. That's the only thing that I see in their creating authority, their powers and their purposes, relative to anything that might resemble what would occur here. It's not to say that they couldn't do it. Again, their predominant authority is to make funds available through these, through private investors and through the issuance of bonds and that sort of thing.
Any follow-up for legal or questions for legal? Seeing none, we'll go back into session. Representative Wright, does that answer your question?
So I think it answers the question that they have an authority to loan money and develop housing, but they're not the placer of people under a roof. They provide building, and they're doing that now. And they have to stay on a footing of, they do not receive allocations from state of Tennessee. So asking them to do something that's outside where we've placed them without sending them some money, because I think it says here the physical impact is,
Non-significant.
I'm on the wrong page. Physical impact is not significant. So to tell the THDA to go do something that's going to cost money and not send money, I can't support the bill.
I can understand.
Representative Cooper, you're recognized.
Thank you, Mr. Chair. I can understand what you're saying. And I'm sure that my misunderstanding of what THDA does, some in helping constituents to get their homes, not their homes repaired, and it may be loans, but they have a list, and it may be just the city and county. The federal funds must come just from federal directly to the city and county, because there are people who are being approved for housing repairs if they're senior citizens. And of course, they told me that he was on the list, that's the housing, that's the city now, that's the county. I don't want to get confused with the state. That he was just on a waiting list, but it's been over 3 years. And my understanding, when I talked with THDA, only didn't say that they didn't have their thought, well, I was just informed wrong, or I heard wrong. I take the responsibility being a teacher myself. I don't want to not take my responsibility. So I'd like to just roll this for next week, if you don't mind, Mr. Chair, so that I can talk with THDA and talk with the Housing and Community Development in Memphis, Tennessee, Shelby County.
Without objection, we'll roll this 1 week.
Thank you, Mr. Chair, and thank you, members.
Item number 5 is our chairman's bill, 680, and he has asked that this be taken off notice, so without objection, we'll take it off notice. I do want to say that I don't normally chair this committee. It's usually chaired by Chairman Carr, and he's having surgery Friday, so please keep him in your thoughts and prayers, and he will be back to us ASAP. But before we close, is there any announcement or personal orders? Seeing none, I'll entertain a motion to adjourn. So moved. We are adjourned.